Essentially, I think a better way to think of it is risks associated with non-compliance. So in general, what's at stake if we're non-compliant with our ADA requirements? Three big pieces. The top two, morality and public trust, cannot be overstated. This is what we started out talking about today. Hopefully, as you've been sitting here listening to us, hopefully that has come across, that this isn't just a box to check. It's not just a requirement to be met. There's a real reason for our infrastructure to be accessible. We're not going to address that in this section. This section's all about that third one. Number 3, we can't overstate the first two. So when it comes to the financial fallout, there's lawsuits. And so there may be fines and awards to a plaintiff in that case. Even if you are in the right, you defend yourself, it's going to cost some money in terms of court fees, attorney fees, things like that. But as we'll see, there's a risk of funding loss with non-compliance, and definitely funding flexibility. We'll see some examples how that is played out. So let's look at the legal situation a little closer. I do have a lot of degrees from the U, but none of them are related to law. So Ann and I are not experts in this, but we can give you the foundation here. So the first kind of claim is a tort claim. A tort is a wrongful act. Government agencies can be sued for liability or negligence in implementing these requirements. The key to a tort is either property damage or personal harm. There's an injury that occurs. Excuse me. It can be hopefully handled internally. Someone makes a complaint, and you take some resolution. Hopefully that's where it ends. But it can jump up the legal system. And as I said, the liability is based on a proof of harm. An example would be, someone gets hurt because they slipped on a steep cross slope, suffered some kind of injury. You can tie that cross slope being excessive beyond the requirements. City was negligent or county was negligent in repairing that. And then tort claims differ from civil rights claims because there's not necessarily an injury associated with a civil rights claim. It's more about a violation or discrimination in general, discriminating in access to facilities, programs, or services based on a disability. So claims must show differential or disparate treatment. Someone with a disability can't attain the purpose for that facility or program. So there's a link to the disability in this case. An example being, let's say your public library or some place where someone is going to vote is only accessible by a staircase. If your disability prevents you from navigating that staircase, you don't have that access to that public good or that public right. Complaints can be filed with MnDOT, Minnesota Department of Human Rights, FHWA, the DOT or DOJ, and lawsuits can be filed in state or federal district court. A couple examples here to show what happens. And for the most part, in these examples, I don't know about a whole slew of others, that there are many cases, but in these cases you'll see the fallout or the penalty. It isn't along the lines of the McDonald's case where someone spilled hot coffee on themselves. They sued McDonald's for millions of dollars. It's not really that. You'll see that the penalties to the agency are a little more focused and constructive. You'll see. So the first example, the first case was Barden versus the City of Sacramento. Really set a nationwide precedent requiring public entities to make public sidewalks and other infrastructure accessible. What happened here is the City of Sacramento in the 90s, so when ADA was fresh, they did a series of mill and overlay projects and did not upgrade the ped ramps as required under the ADA that we talked a lot about this morning. The resulting settlement was that the city had to allocate 20% of its transportation budget to make the right-of-way pedestrian accessible for up to 30 years. Doesn't really matter what your budget size is, 20% of it for 30 years is a significant chunk. Yes?
You used the phrase, they didn't upgrade their pedestrian ramps, but I'm wondering if they just didn't have any pedestrian ramps and they just drove the mill right by the
It could be.
curbs and never...
It could be. Either they weren't there and were supposed to be and they should have been installed with the project, or they were there but non-compliant and had to be made compliant.
Yeah.
Yeah.
I bring that up, 'cause one is terrible.
Sorry?
They didn't put the ramp, if it was curved and they didn't put ramps in, that's kind of not nice.
Right. Yeah, Todd?
I will throw in that Barton also had very bad sidewalks as part of that case. It wasn't just curb ramps, the sidewalks were inaccessible. That was a large contributing factor.
Okay, because the improvements that the city was required to make related to the whole pedestrian infrastructure, not just curb ramps. But you'll see the law specifically called out curb ramps. The penalty pertained to the entire pedestrian infrastructure. Now, if their entire pedestrian infrastructure is made accessible before that 30 years is up, then they've done their job. But I think you can agree that the financial loss of funding and flexibility was, the loss of funding flexibility was pretty big.
So then in 2012, was all that work considered non-compliant?
Depends when it was installed. Potentially. Yeah, potentially.
Most likely, yes.
So, yeah.
Well,
You can
yeah.
say it, Brady.
I think so. I think it would be non-compliant. The stuff that was built before 2012 is probably non-compliant under the new standards.
I would throw out there though, the sidewalk cross slope since 1971 on curb ramps has not changed.
That's one aspect, right?
2%. The running slope on a ped ramp, 8.3% since early 70s. So.
Right. It's a good,
Struggling with these numbers, but a lot of them haven't changed. The basis of them have not.
the main way to miss compliance is in those slopes, and those have not changed since the Architectural Barriers Act came out around 1970. So if you miss those slopes, you're going to miss it no matter what, and you'll continue to miss it. But there are some subtle differences that have changed, yes. Good point. It gets more recent and closer to home. I don't mean to single out St. Paul, but it's a public knowledge, public settlement here. Similar situation in that the city of St. Paul undertook some mill and overlay projects in 2014 that should have required or did require those ped ramps. I think it was a couple dozen ped ramps to be reconstructed. They weren't. Complaint led to a case by the Minnesota Disability Law Center where the city was forced to spend $2.5 million on those improvements, which included over 200 curb ramps identified for reconstruction. So the couple dozen ramps that should have been done with the mill and overlays turned into over 200 ramps and $2.5 million. So it is a lot of money, right? Those are real dollars at play. But it's a fairly reasonable place for the money to go. It's not like it went to the one complainer, plaintiff, in some big payout. Make sense?
Did they get a fine on top of it?
This was a settlement, and typically the settlement shows up in the fact of improving infrastructure. I guess I don't know if there was a fine or not. This one we've been talking about all day. It's worthy of its own slide at this point. FHWA can be and is being withheld for noncompliance or for not having your evaluation and transition plan in place at the time that you apply for funding. Bring up the DOJ again. We had this slide in the first section to talk about the DOJ driving steering the ship when it comes to the ADA. They issue regulations, they coordinate compliance activities, and they enforce requirements. Let's see how they do that. One primary way is through this program called Project Civic Access. Anyone heard of this? Met Council, good? Okay.
Where I lived before, our two largest cities were under settlement agreements with DOJ under this program, so it's not something you want to go through.
Okay. So what cities were those, or where would you live?
Kansas City, Missouri, and then Kansas City, Kansas, and Wyandotte, Kansas.
Okay. So we'll walk through what generally happens and then go through an example here so you can see how they exercise their authority. The Disability Rights section of the Civil Rights Division of the DOJ, they conduct reviews of local governments to ensure compliance with Title II. So far they've had over 200 settlements, at least one in all 50 states. And it's within their authority the DOJ's authority to conduct those reviews kind of at random in their desire to hit a variety of agency sizes and locations. It can also be in response to filed complaints. So if they're aware of some situation within a given agency, complaints pop up multiple times, that may bump you up the list, make you more likely to be reviewed. And what happens through all this is after the review, there's a settlement agreement to resolve the balance of compliant, non-compliant issues. Here's a list of somewhat local ones that have been reviewed in the last 10, 15 years. You can see a couple in Minnesota, none since 2005 in Minnesota. But we'll talk about this Milwaukee case, which you have an example of in your binder. So, what happens? The DOJ will request data from your local governments, either to submit or maybe have phone conversations and interviews, and they conduct physical surveys of the government facilities. I can't say for sure that they do every ped ramp like you guys would, but they will check some. Your whole government gets reviewed. So while we focused on the right-of-way for the most of our Section 3 today, they look at everything. And so a lot of the things that they pull out will be related to things outside the right-of-way, like programs and your public buildings and things like that. So they'll request physical modifications of facilities. They'll also do a number of other things that aren't on this slide. I'll read them off here. Physical modifications to polling places, establishment of an ADA grievance procedure. Again, these are all required under the ADA anyway. Strengthening of 911 emergency services, better telephone communication, and adoption of procedures for relocating inaccessible activities to accessible locations. They have a document where they call out common problems that they find under these reviews. You have this in your workbook. Some of the pictures didn't quite print right. I believe these are two that didn't print right. So hopefully you've learned enough today to know why this is a problem.
Hopefully.
Or you knew before you got here. That's fair too. We didn't talk a lot about bathrooms, but what's the problem here?
The wheelchair won't fit underneath the sink. It looks like.
Maybe. We have to check the knee and toe clearances.
Oh, with that board going across the front.
from the door.
Clearance space is the for sure one we can pick out, right? No room to pull that door open and have a space for the wheelchair to maneuver.
So wash your hands, but it might be tough to dry them.
Yep. Heights of all those fixtures are controlled.
All of them are so far back.
Yep. Might exceed the reach requirements. This one I think is okay with it, but a lot of times if this unit isn't here, pipes could be exposed from the bottom, could have hot water in them or cold water in them, and so a wheelchair will put you right under next to those pipes. Lots of things in bathrooms that have potential to be problems. Another document that's also in your workbook, best practices toolkit. Service counters should be provided. Again, doorway clearances and opening mechanisms are a part of this. So, last thing we have today is to walk through this example. You have the entire document. We're not going to cover the entire document. If you're having trouble sleeping tonight, please take it on at your leisure. So we're going to walk through what happens here. Pulled out some language from the introduction of the document. You can see it's all legal speak. Based on its review of programs, services, activities, and facilities, so again, really your whole government service, the United States has concluded that qualified individuals with disabilities may, by reason of such disabilities, be excluded from participation in or denied the benefits. It goes on. And it concludes by saying, in order to avoid the burdens and expenses of a further investigation and possible litigation, the parties enter into this agreement. So then the document goes on and spells out the terms of whatever the agency being reviewed has to do under this authority of the DOJ. So we have a few examples. In all these examples, you'll see that there's a what and a when component. What does that sound like? It's a transition plan, right?
Right.
Where you specify on your own what improvements you're going to make and by when. So all these examples have that, and chances are the timeline that the DOJ imposes for you in this settlement is going to be a little more real, and you're going to be held to it more than your self-imposed transition plan. So an example, within 3 months, the city will adopt the ADA grievance procedure, distribute it to all of its agencies, and post copies of it in conspicuous locations in each of its public buildings. Now we're starting to get some clarity, right? And it's got to happen in 3 months. Also within 3 months, the city will make all voter registration materials available in alternative formats, including Braille, large print, so on. Immediately, the city will provide curb ramps or other sloped areas at all newly constructed or altered pedestrian walkways where they intersect a street, road, or highway. What does that sound like?
It's gonna start tomorrow.
DOJ, Joint Technical Assistance, the FHWA, right? First thing we talked about today for the most part. So again, these aren't coming out of left field, right? You've been aware of these, we've talked about them. They're requirements under the ADA, and you're just going to do them now because we found that they haven't been done. There's a whole bunch in there. There's 70 of them in there. I pulled 3. Any questions on that? Because at this point, we've reached the end. So you guys are really lively. We covered a lot of ground this morning, lots of questions back and forth. That was good for Ann and I. We have had some lively classes and some not lively ones. We find you guys probably get the most out of the lively ones. People stay awake and so on. So we'll be sticking around, cleaning up. We can answer one-on-one questions. My card was on the table if you have any follow-up questions. Other than that, I hope you got at least what you came here for today. And look for those announcements for future classes.
Okay. Yeah, we're not in any rush to leave, so if you have additional questions, come on up and talk to Brady. Not me, but Brady. I'll be the one cleaning up the room. He's the expert. And pretty qualified, if you ask me.
Yeah.
Follow-up question on self-evaluation.